So I just want to give him an opportunity perhaps to respond to some of the comments that have been made by the speakers, if you wish to do so, obviously. Please.
Thank you again for the inputs. I have enjoyed it. Not much to comment because I do share the views which are complementary and the concerns which lie behind. The concerns are precisely those related to the variety of situations from which we depart. We are determined. There's no turn back. There's no escape from that horizon of incorporating new technologies in all of its potential, including artificial intelligence, whatever it means, because there is an ongoing discussion about the content, about the perimeter of that intellectual challenge of how to deal with algorithms when ruling basic aspects of our everyday life, including the way we enjoy our fundamental rights. But having said this, there is an additional legal challenge, which is precisely the variety of specific features which are presented both by legal professions, lawyers, and judges and public prosecutors, which are fundamental for the realization of the rights which are involved, which are the subject matter of our concern. And that means that despite that variety of institutional features, which are unsurmountable because they are there to stay, we have to make sure that the basic protection of the rights involved is consistent with the European standards, which are enshrined. The values of Article 2 and the rights enshrined in the Charter, including, as I said, 7 and 8, rights to privacy and confidentiality of data. When it comes to facial recognition, when it comes to evidence in criminal procedures, not only in criminal procedures, you may think also of the application of those principles to civil procedures or liability cases, but particularly in criminal procedures, because those are the ones which challenge the most the right to liberty. And I think that is an important issue, but also equality and non-discrimination, Article 20 and 21, and of course the rights which are encompassed in the chapter devoted to justice. And having that in mind, I think the right input is that legal professions, which have been very successful in incorporating artificial intelligence, algorithms, new technologies, and digitalization, do make sure that in their institutional communication with the political politically accountable people in their member states, including ministers of justice, are also having in mind this European framework in which we are bound to meet each other sooner than later, so that the tools that we are putting in place to secure judicial cooperation are not diminished, but on the contrary, they are enhanced, they are strengthened, they are reinforced by this technological revolution, for which we need literacy and training, a real lot of training, both by the legal professions and the responsible people in charge to carry out their strategies, the national strategies to incorporate digitalization in the field of justice. I thank you so much.
Thank you. Many thanks. Yes, I don't think you can longer stay with us. I think you have something coming up now. So Well, again, thank you for sharing your time with us, and we look forward to any future collaboration. I would like to give now the opportunity to some of the participants to ask a question. We have also Ian Mitchell, who could basically respond to anything related to James' presentation, because we foresaw him to stand in case James would not be able to stay for the discussion. So Ian can take any questions from the audience if needed on that part. I see Louis Bernard Buchmann. Please, if you can hear and see. Yes, I think we can already activate your mic.
Yes, thank you.
Yeah, and your camera as well. Yes, we hear you.
Thank you.
Yes, please, if you can introduce yourself. We, of course, in the CCB already know you, but for the other people.
Thank you, Simone. Yes, my name is Louis Buchmann. I'm a member of the French National Bar Council. I have two remarks. One is in reaction to what Mrs. Railing just said, which we very much approve. And the other one is in connection with what James McGill said. With respect to the presentation by Mrs. Railing, I'd like to inform you that the French National Bar Council approved on October 8, that is this month, a very comprehensive report on legal texts in the field of forecast justice. I agree with Mr. Reeling that predictive justice is a misnomer. And this report includes a charter which is very much derived on the charter of the Council of Europe, of CEPEJ, and already one of the important actors in the market in France, a company named Case Law Analytics, has signed up to this charter. I would be very keen on making this report available to the CCBE, and I was going to suggest to send it to Simone Cuomo, who then can forward it to whoever is interested. It's in French, obviously, but most of you and many of you do read French. So that was my first suggestion. And the other one is in connection with what James said earlier, and again, I very much approve what he has said. It so happens that the French National Bar Council is preparing a comprehensive report on video hearings and the effect of video hearings on on justice, and this report is going to be presented at our general meeting on the 13th of November, that is in a few weeks. And if approved, I'll be very happy again to make it available to all interested parties through Simone Cuomo, if he wants to, he consents to play the middleman on this. So these are not questions really, but just bits of information which I thought would be interesting, maybe to some of you. Thank you.
Yes, absolutely. We will be happy to share that. So I see there is also Yuri who wishes to comment on some of the remarks made. Please, Yuri.
Hello again. Well, basically, this is just a comment, maybe. Well, from what I heard from Ms. Reiling and of course, and also the previous speakers, what comes to me is a new right to a human right. A new right to a human judge that we basically see here, maybe as a part of the a fair trial principle. But what I wanted to comment to the nice presentation that we just saw is that the question with AI and with AI is also how much the human judge will be influenced by the AI support in this sense. And you gave the example of Compass, very well known to us. But then the question is, will be the defendants in criminal cases technically and well, by their experience, even capable to challenge the AI support? Will they be able to say, well, I don't think that what the AI support gives you, the judge, I don't think this is right, and I think this should be done otherwise? Will the defendant or their lawyers will be able to challenge that? I think that's an important question, because if not, then again, who is the judge going to follow? I would be afraid that it would be the AI support.
Yeah. Yeah, please, Dori, if you want to comment on that.
Oh, yes, absolutely. This is precisely regarding my point of ex ante or ex post transparency. And clearly, and I think the ethical principles also stress that this access to the technology, and in order to be able to properly defend a client, is necessary. So I fully agree with you.
Okay, Ian, do you have perhaps something to say on that?
Yeah, I do actually, because I think that this discloses, a need for education that goes beyond actual education in the systems to extend to really education of society as a whole. Let me explain. I mean, those of you of a certain vintage and cultural background will know all about the Little Britain sketch, where the low-level civil servant will just stare somebody in the face and says, "The computer says." And it's an issue which, of course, is recognized in the GDPR, Article 22, the need for human review. But there's a case just about to be brought in the Netherlands regarding Uber, who have developed, they believe, a whiz-bang algorithm which can tell if their lawyers are defrauding the company. And then based on the algorithm, they summarily dismiss their lawyers from use of drivers from use of the app. They claim that this is subject to human review, but I have a feeling that the human review is merely looking at what the algorithm did and agree with it, because there isn't knowledge base to actually dispute it. And you do have to remember that the notorious Loomis case actually ended up with a victory for the marketers of the algorithm, because it got as far as the Wisconsin Supreme Court and no further, and the Wisconsin Supreme Court couldn't see anything wrong with it. And what this talks about is, I think, essentially a complete failure on the part of society to appreciate the limitation of artificial intelligence. And because artificial intelligence tools tend largely to be black boxes, you can't check the data set that they've been educated upon. Even if you can check what the particular data set is, you generally don't have the methodology which brought about the compiling of the data set. Going back to Loomis, it was a reflection that partly the police tended to arrest more black people than white people because they patrolled black areas more. And they patrolled black areas more, perhaps because they were racially biased to begin with. So if there is no understanding of the data sets, if there's no understanding of the way in which the whole thing is built up, it doesn't much matter if you're giving specific education to defense lawyers, because if they don't understand the basic premise behind the whole thing, and I think society has to understand the basic premise behind the whole thing, I don't think you can do what the French did, which is to say, let's just ban it, as they did in relation to analytics of judges, because after all, without a computer, good lawyers have been for centuries trying to double guess how the judge thinks and what sort of arguments the judge is going to respond to. And you can't use the new technology as an excuse for banning things which people have been doing properly for centuries, any more than you should slavishly accept it. And I'm sorry, that's far too huge a topic and probably provoke far more time than we've got for discussion. But I do think we have to get beneath the surface.
Oh, very interesting. Thank you. We have also a question from Erik Velgaren. So I want to also give him the opportunity, because he has been waiting for a while already, to come to ask his question. Mr. Velgaren, yes, please, you can introduce yourself.
So good morning, I'm Erik Velgaren. I'm a member of the Flemish Bar Council in charge of digitization. I was particularly fascinated by the contribution of Ms. Dori Reiling, and maybe also in line with the comment made by Mr. Mitchell. I'm obviously intrigued by the possibilities offered by AI in the administration of justice, but how can we organize this transparency in a useful way if there may be a problem with the education or the understanding of the technology? What should we do? Should we add more external experts to courts or judiciary in order to make that possible? Will we strong arm providers into sharing source code and documentation and have extensive IP discussions with them? So that's a first point. A second point, and then I'll stop, is I also have a concern about the growing use of cloud computing in anything dealing with digitalization of justice. There's a lot of very interesting tools out there, but more and more they are entirely based on cloud platforms. And then I hit the issue of our own CCBE rules relating to the use of cloud, which I think go back to 2012, which in terms of digitalization is when the animals were still speaking. But if you read those rules, the question is, how can you as a practicing lawyer in a responsible way go into the cloud without violating the rules of your own professional organization? Thank you.
Thank you. Well, in response to that last matter, I can already inform you that we are indeed reviewing those guidelines on the use of cloud computing, which indeed are from 2012. So we are indeed reviewing that. I don't know, Dori, if you perhaps want to say something on those points.
Oh, let me speak to the first point. The challenges for judiciaries and court systems when they start to use technology like this are enormous. And my worry is that court systems do not probably are insufficiently aware of how big the challenges are. And it's my strong conviction that the only way to go about this is that judiciaries and court systems themselves have to be responsible for the quality of their data, their security, the algorithms they use, and there's already a little bit about that in my article. It's one of the things I think that I would like to develop more, because I think it's really important, but it's an enormous challenge, and I don't think that judiciaries are ready for it at all.
Okay, yes, unfortunately, we have to close the discussion